What's up, everybody? So yesterday I made a video talking about how Stephen Avery has filed something new with the court. It was a motion for miscellaneous relief, and when asked what that meant by Case 10 on X, Kathleen Zellner responded with, Stephen Avery is exercising his First Amendment rights after 38 years of incarceration for crimes he did not commit. Now, I didn't really know anything further about that at the time, but Fox 11 online.com has posted the actual filing, and we're going to go over it here. But first, we will talk about the article that Fox11online.com has posted. Thanks again to Case 10 for pointing me in the direction of this article. Stephen Avery petitions Wisconsin Supreme Court, claims miscarriage of justice. Stephen Avery personally wrote the Wisconsin Supreme Court asking for a new trial, saying he is the victim of a setup and it has to be fixed now. After a state appeals court denied his latest appeal, Stephen Avery's attorney asked the Wisconsin Supreme Court to take the case. It has not made a ruling on if it will do so. Despite that official process being underway, Stephen Avery typed a 6-page letter, which we have and will go over, to the court from Fox Lake Correctional Institution, addressed to the Chief Justice, raising some of the same issues his appeals have addressed and were rejected by the courts. The real killer could have killed again, and the state is protecting him of my miscarriage of justice. New trial should be granted for miscarriage of justice. Defendant was convicted of an offense that he did not commit. The criminal justice system is broken and has to be fixed, and this is the time to fix it and get it right, because I'm a victim of a setup and it has to be fixed now. Among the specific claims Stephen Avery makes, that Sheboygan County Judge Angela Sawitsky, who denied several motions at the circuit court level, turned a blind eye to much of the evidence and also refused to admit probative, admissible evidence that, when evaluated under the proper standing, is damning. That the courts should allow him to blame another suspect for Teresa Halbach's death, that his rights were violated when it returned remains to the Halbach family. Prosecutors have not responded to the letter. Stephen Avery's nephew, Brendan Dassey, was also convicted. Dassey's appeals have all been rejected and he has none pending. So let's go over the actual filing here. I will link it in the description below so you can go have a read for yourself. It was filed and dated March 13th, 2025. State of Wisconsin in Supreme Court. Filing a complaint on this case of fraud and due process rights and all the evidence of judges behaving badly by I'm going to read it just like he wrote it, because I'm assuming he meant by turning a blind eye, turn a blind eye on the evidence and all the Brady violation of this case, and this will give me a new trial on this case. Judges behaving badly. What a title. Judicial misconduct refers to acts that are unethical, illegal, or in violation of the judicial obligation of impartiality, as we have seen. There are many ways in which judicial misconduct rears its tainted head. More often than not, misconduct is subtle. Some of it is blatant. Fact. Based on evaluation of weight of evidence in a claim. The 14th Amendment secures the right to due process. The 8th Amendment prohibits the use of cruel and unusual punishment during an arrest or detention. These rights can be violated by the use of amounting to punishment. Summary judgment. The person accused of a crime must be allowed the opportunity to have a trial and should not be subjected to punishment without having been afforded the opportunity of the legal process. Failure to keep from harm. The public counts on its law enforcement officials to protect local communities. If it's shown that an official willfully failed to keep an individual from harm, that official could be in violation of the color of statute in the true of justice. I'm assuming that it's written. There's words obviously. I mean, there's words obviously missing here. There's a couple typos. It's hard to read because it's not exactly how one would speak, but doing my best here. In the true of justice, I assume that means in the truth of justice. Reached by an actor framed for murder. How important is the question of innocence to a judge? Judge who rejected over and over his or her claim that he was a victim, that is there twice, he was a victim of police and prosecutorial misconduct, and his exoneration didn't matter to the Wisconsin court. And his exoneration didn't matter to the Wisconsin court that rejected his estate's claim for compensation for his wrongful conviction for the second time. RAV4 Bobby attempted to step in front of his car to block him from leaving the property. It feels like there's a page missing, but who knows. RAV4 Bobby attempted to step in front of his car to block him from leaving the property. Mr. Sawinski was within 5 feet, or maybe they're just putting a specific quote here. Mr. Sawinski was within 5 feet of Bobby, and his headlights were on Bobby during the entire time. Mr. Sawinski swerved into a shallow ditch to escape Bobby and exit the property, but that's spelled wrong. After Mr. Sawinski learned that Teresa Halbach's car was found later in the day on November 5th, 2005, he realized the significance of what he had observed and immediately contacted the Manitowoc's sheriff's office and spoke to a female officer, reporting everything he has stated in his affidavit. This was the 8th Brady violation the state held. The issue on remand to the circuit court was whether the state violated Youngblood versus Arizona when it returned the human bones to the Halbach family in 2011 without giving notice to Stephen Avery or his counsel. Stephen Avery's supplemental motion alleged material facts sufficient to establish a violation of the Wisconsin evidence preservation statute and Youngblood because it does not provide a remedy for convicted persons in the event of a violation. Fashioning a remedy is left to the courts in action Wisconsin courts have yet to take. Mr. Avery's supplemental motion contains sufficient material facts for the circuit court to fashion a remedy for evidence preservation violations controlled by the United States Supreme Court precedent addressing evidence preservation. Taken together, oh good God. If a criminal defendant can satisfy either test, then a court will rule the destruction of evidence was a violation of due process, reverse the defendant's conviction. I should had a new trial on all the new evidence. Probably I should have had a new trial, or I should have a new trial on all of the new evidence. The circuit court abused its discretion in dismissing Mr. Avery's second motion pursuant to Wisconsin statute without addressing the 5 Brady claims raised, and in denying Stephen Avery's motion to supplement, which raised a 6th Brady claim, all of which deprived him of due process in violation of the Wisconsin and United States Constitution. Standard of review: Brady violation of Mr. Ramlow, Brady violation of Mr. Redant, Brady violation regarding original flyover video taken on November 4th, 2005, Brady violation regarding the zipper voicemail, Brady violation regarding Miss HEITL, Brady violation on Dassey Janda CD computer that Bobby Dassey was using, and it had all this stuff on it to access violent images of young deceased females, rape, torture, incest, and pedophilia on the internet at times when only Bobby Dassey was home, and he had a picture of Teresa Halbach and Stephen Avery, and this looks like a good suspect to the case. And the new eyewitness, Thomas Sawinski, Mr. Sawinski was a motor route driver for Gannett newspapers and delivered papers to the Avery salvage yard in the early morning hours of November 5th, 2005. Prior to delivering the newspapers to the Avery salvage yard, he turned onto the Avery property and witnessed two individuals, a shirtless Bobby Dassey and an unidentified older male suspect, pushing a dark blue RAV4 down Avery Road towards the junkyard. The RAV4 did not have its lights on. After Mr. Sawinski drove by Bobby and the other individual and delivered the papers to the Avery mailbox, he turned around and drove back towards the exit. When he reached the... Yeah, they put this in the wrong order. That's what it was. When he reached the RAV4... So I read the beginning part of that. The part where I talked about how it seemed like there was a page missing, it's because it's out of order. Page 5 should be page 4. So it goes on to when he reached the RAV4, Bobby attempted to step in front of his car, blocking it from leaving the property. So let's go to page 6. Because, where am I? Because the state violated with a Wisconsin statute, Mr. Avery has sufficiently demonstrated the bad faith requirement of young blood for an evidentiary hearing. Alternatively, this court should grant a new trial to Stephen Avery in the interest of justice. Mr. Avery has demonstrated that the real controversy in the trial was not fully tried, and therefore it is probable that there was a miscarriage of justice. And Bobby Dassey's Veal computer CD evidence of motive. Bobby has the motive to murder Teresa Halbach, and the killer is still out there to this day. The real killer could have killed again, and the state is protecting him of my miscarriage of justice. New trial should be granted, he has granted, for miscarriage of justice. Defendant was convicted of an offense that he did not commit. The criminal justice system is broken and it has to be fixed, and this is the time to fix it and get it right now, because I'm a victim of a setup and it has to be fixed now. And ooh, it even posted like the front of the envelope, I guess, that he mailed it in. Interesting. And I've never seen that on one of these before. Stephen Avery, he dated this March 3rd, 2025. So, couple of things. I wonder if they sent it as is because of how it's written, and they want the judge to know exactly, or whoever this goes to, exactly how Stephen Avery speaks and writes, and it's not very correct. I mean, the guy's been in jail now for what? 18 years one time, 19 years another time, 20 years another time. A very long time. 38 years, I think, is a total of 39 years. And that's how he writes and speaks after being in prison for that long. Or did he not tell Kathleen Zellner he was putting this? Because I would think maybe Kathleen Zellner or somebody on her team could have made this sound a little better, but perhaps, and at least put it in the right order. Or perhaps, maybe this was just posted in, no, because the pages are numbered. Or maybe perhaps she didn't know, and or she did know, and they just wanted to have this come directly from Stephen Avery, directly how Stephen Avery writes and speaks. It's interesting. Especially with the Supreme Court thing already underway, that he's doing this now. But what do you think? What do you think of Stephen Avery writing this letter? Do you think it will do anything? Do you think it will help? Or do you think it will just get swept away because of the other motions that are already in play, or the other stuff going on with the Supreme Court and they're waiting to hear back from that? What do you think, if anything, this is going to do? Let me know. Leave some comments below. I hope you're having a good day, and I will see you again soon.